Hello, everyone. Welcome to Internet Law Review. Today, we're here to discuss the case of Tharpe versus Sellers, but more specifically, we're here to discuss the issue of race as it applies in jury trials, and if and whether and how we should try to figure out whether race is being used improperly in jury convictions. So, the background here is that Tharpe was convicted of murder and sentenced to death in the state of Georgia. He exhausted his state appeals. And under federal law, he cannot automatically appeal a conviction related to a death penalty case to federal courts, except under very limited circumstances. One of those circumstances being a writ of habeas corpus. The writ of habeas corpus is one of the most ancient rights. It's actually specifically protected in the United States Constitution. And the writ of habeas corpus basically says that you have to prove why someone is being held. But it is a very high standard. You don't have to show very much for why someone is being held. Any sort of criminal conviction will do. So a writ of habeas corpus is a very, very high standard to overturn an otherwise legitimate conviction, and the courts are somewhat reluctant to grant them. But one such instance that the courts may grant them is in the issue of race. The issue of race and how it affects criminal trials and criminal convictions, and whether or not it should allow courts to look at jury trial verdicts, was first brought to the court very recently, 2017 as a matter of fact, in a case called Peña-Rodriguez versus Colorado. Under common law, which goes back to the founding of America and even further back than that, in English common law to the year 1066, jury trials and jury verdicts are considered sacrosanct. You do not go into the jury room to figure out why the jury reached a certain verdict. The idea of what the jury is talking about and how they reach the decision is considered something for the jury and the jury alone. You might have heard the saying, "What happens in Vegas stays in Vegas." While that particular saying doesn't have much legal reality, in jury trials, what happens in the jury deliberation room stays in the jury deliberation room. It is very, very, very frowned upon to figure out what the jury is talking about in a jury trial. And the reasons for that might be fairly obvious upon a little introspection. Juries have to talk about lots of different things. They have to look at the facts and they need to talk about it in a very frank, open way, in an open dialogue, and have things open to exploration. And a jury might feel reluctant to talk about things in a truly open way if they felt that their words might come back to haunt them in terms of being reviewed. You know, if you or I, our words, our dialogue are being taped and going to be reviewed and subject to judicial review by courts, well, we're going to have a much different conversation than if we know that our words are going to be held secret. And the idea, at least, is that the free flow of exchange of ideas, people being able to speak with absolute liberty, absolute freedom to say anything that they want in the terms of trying to explore whether or not a person should be convicted of a crime, is worth the cost. That we need people to be able to engage in a truly deliberative dialogue to determine whether or not someone should be convicted for a crime. And as a result of this, the idea of whether the jury is sacrosanct or not has been very well established in common law. This standard was first changed in a fairly dramatic way in the modern era in the case of Peña-Rodriguez versus Colorado, where a person argued that their jury convicted them on the basis of race. The courts had said that they couldn't even ask the question because jury verdicts are sacrosanct. But the United States Supreme Court, in a fairly controversial 5-4 decision, determined that that was improper because race is one of the great American original sins. Race is different. And because race and racial prejudice goes so deep into the American experience, if someone is being convicted because of their race, that may be one circumstance when the jury's sacrosanct nature might be legitimately pierced. The lower court had found that there was no sufficient evidence of prejudice in connection with the rape, saying that Tharpe had failed to demonstrate that the behavior of a juror named Barney Gate had substantially and injuriously affected or influenced in determining the jury's verdict. So the Court of Appeals had found there was insufficient evidence to grant the writ of habeas corpus. The United States Supreme Court felt that the Court of Appeals improperly dismissed a sworn affidavit signed by the juror in question in which the juror apparently admitted improper bias. The juror in the death penalty trial had signed an affidavit indicating that, according to the juror believed that there are, quote, two types of black people, black folk and N-words, and that the defendant, Tharpe, wasn't in the good black folks category in the juror's book, should get the electric chair for what he did. Some of the jurors voted for death because they felt Tharpe should have been an example to other blacks who kill blacks, but that wasn't his reason, and that, after studying the Bible, I wonder if black people even have souls. The United States Supreme Court felt that this statement was given improper consideration by the Court of Appeals, and that the Court of Appeals should have given further consideration as to whether this statement, along with other evidence, showed a clear and convincing evidence that the factual determination of the state was wrong. Factual determinations by lower courts are normally given a high deference, and you need to show that they are improper by clear and convincing evidence. The United States Supreme Court felt that the Court of Appeals did not properly give this statement enough attention in its opinion in determining whether or not there was clear and convincing evidence. It's important to note here that the United States Supreme Court themselves is not saying that the statement is in and of itself sufficient, but rather they're saying that the Court of Appeals did not give it a proper delineation. In fact, the United States Supreme Court says, quote, "We express no view of those issues here. In light of the standard of relief from judgment, which is available only in extraordinary circumstances, Tharpe faces a high bar." The United States Supreme Court simply felt that the Court of Appeals did not give sufficient consideration to this critical piece of evidence in determining whether or not the bar was met. Stating specifically, the United States Supreme Court says that under the unusual facts of this particular case, the Court of Appeals review should not have rested on the ground that it was indisputable among reasonable jurors that the juror service did not prejudice Tharpe, and therefore grants the petition and vacates for further consideration. The issue of whether or not a jury's verdict should be pierced in order to try to determine whether or not they reached a verdict for an improper consideration is a deeply, deeply troubling one. No one believes that a jury should be able to convict on such clear racial animus, but whether or not a court should be able to ask that question is a whole nother problem. Because if you can ask that question, there's no obvious limiting factor. If you can ask the question on the basis of race, can you ask the question on the basis of other factors? This issue of whether or not we can pierce a jury's decision to determine whether they made an improper decision on the basis of race naturally raises the question, can we pierce it for other factors? And this is not strictly an academic question. In fact, fairly recently, the United States Supreme Court denied a writ of certiorari in a case that's described by this article, entitled "A Jury May Have Sentenced a Man to Death Because He's Gay, and the Justices Don't Care." According to this article, in the factual background, there was evidence to show that the jury had often discussed that the defendant, Mr. Rhines, was gay, and that there was a lot of discuss about it. One juror recalled in an interview according to a court petition. Another said the jurors knew he was gay and thought that he shouldn't be able to spend his life with men in prison. A third recounted hearing that if the jury did not sentence Mr. Rhines to death, if he was gay, we'd be sending him where he wants to go. The petition for the writ of certiorari in this case from South Dakota also focused on questions that the jury asked as part of their deliberations, where you can submit written questions. The juries asked some questions that appeared to relate to gay animus. For example, whether Mr. Rhines would be in the proximity of other men in prison, would he be allowed to mix in with the general inmate population, would he be permitted to discuss, describe, or brag about his crimes to other inmates, and would he be allowed to have a cellmate. I do think it is slightly glib to say that the justices don't care. The issue is whether or not the jury's deliberation should be pierced, and if at all. And having determined that we should pierce on the basis of race, it is naturally the next logical question whether or not we should pierce for any other grounds. This is why the decision to pierce on the basis of race in Pena-Rodriguez versus Colorado was a 5-4 decision, because the limiting principle is not obvious. If you can pierce on the basis of race, can you pierce on the basis of sex? Can you pierce on the basis of gay animus? Can you pierce on the basis of other things? And where does that end? Will juries no longer feel free to discuss what they should And will that ultimately prove to be more negative to the criminal justice system than the inquiry itself seeks to redress? It's hard to imagine something much more serious than whether or not someone should be sentenced to death when we're talking about criminal justice. Mr. Tharpe has a reasonable argument that a jury improperly considered his race as part of his sentence and determining that he should get the death penalty. There is sufficient evidence on record that suggests that this may have been the case, and the Court of Appeals improperly considered it. Whether or not this ultimately will benefit Mr. Tharpe has yet to be decided. A court still has to decide whether or not it's sufficient to overturn the verdict or otherwise give Mr. Tharpe some other kind of relief. But the broader issue is, under what circumstances, if at all, should we look to a jury's true motives in determining whether or not they convicted for quote-unquote the right reasons? This is not a trivial question, because the question goes to whether or not the jury will feel free to discuss everything that they should feel free to discuss about. And if we open it up to a broader inquiry, will that ultimately hurt people because it will hurt the free flow of information? I open it to your consideration to consider these factors and the balance of these factors and how we do justice both in individual cases and in the broader cases, and what we should consider and what we shouldn't consider in determining whether or not verdicts or sentences were fair. For now, my friends, that's all. Until later, cheers. Bye.